Please, Pivot, please go ahead.
Thank you. Good afternoon, Honorable Chair and members of the committee. My name is Caitlin Shane, and I'm a lawyer with Pivot Legal Society. I'm joined today by Naomi Moses, who is a lawyer and one of Pivot's board members. Pivot is a human rights and legal advocacy organization based out of Vancouver's Downtown Eastside. We take our mandate directly from our clients, who are sex workers, people who use drugs, people without homes, and people who by and large are living well below the poverty line. On behalf of our clients today, we urge the committee to support the proposed amendments to the victim surcharge provisions. It is critical to return discretion to judges who, under the current legislation, do not have the discretion to waive the fine for defendants who cannot pay. We do have some minor recommendations, and I will leave that to Naomi to discuss shortly. But by way of background, when Pivot intervened before the Supreme Court of Canada in a decision that challenged the constitutionality of the victim fine surcharge, we made the argument that the mandatory surcharge amounted to cruel and unusual punishment. And we explained what it means for a poor defendant to appear before the court and be imposed a fine that they will not be able to pay. And my hope today is to explain to the committee some of those harms that we explained then. So for the defendant who manages to pay the surcharge, it means having $100 less from the $335 that person earns on income assistance each month to pay for food and clothing and basic necessities. For the defendant who doesn't pay, it means being subject to civil enforcement. And in BC, the surcharge can be offset from social safety net funds, from bank accounts, and from wages. For the defendant who applies to extend the deadline for payment, a payment that this person may well never be able to pay, it means engaging repeatedly with an application process that is lengthy, that is inaccessible, and that is not supported by province-funded legal assistance. For the defendant who defaults on payment, it means living in fear of the constant consequences of default, which can include arrest. And it doesn't so much matter whether arrest is a likelihood. The Supreme Court of Canada has found, in relation to both sex workers and people who use drugs, that fear of arrest can lead to really dangerous consequences. It means being cut off from service providers. It means not calling police when there's an emergency and help is needed. And it means isolation amidst housing and opioid crises. And we submit that the surcharge applies to the same scenario. It's still relevant. A person who lives in fear of being imposed with imprisonment is subject to those same risks and will not necessarily rely on help when it's needed. So judges across BC have recognized these harms and, despite common law precedent, routinely sentence offenders to a day in jail in default of payment. While this practice may be alarming, it is not rooted in malice. It's rooted in mercy and on recognition of the fact that this defender cannot pay, and there are no other options for the defendant who cannot pay. So I'll just close by saying that the Parliament today has an important opportunity to remedy the harms created by the mandatory victim fine surcharge, and we ask only that the provisions be made as accessible and as responsive to the needs of low-income communities as possible. And so I'll turn it over to Naomi now, who can better explain those. Thank you.
Good afternoon, Honorable Chair and members of the committee. I'm a lawyer at Rosenberg Kosakoski Litigation in Vancouver, and I'm here today on behalf of Pivot Legal Society. I echo my colleagues' acknowledgement that this proposed legislation is an important step in ameliorating the reality that Pivot's clients, many of whom live in extreme poverty in the Downtown Eastside of Vancouver, have been very negatively impacted by the mandatory victim fine surcharge. We also have some concrete recommendations for improving these proposed amendments. I'll focus my submissions on only one part of the proposed amendments, that's section 737, subsection 5. As it is currently drafted, this provision allows offenders to be exempted from payment of the victim fine surcharge, provided that they can establish to the satisfaction of the court that it would cause them undue hardship. The individual must apply to the court for an exemption. We believe that the wording of subsection 5 should reflect what judges did in practice prior to the 2013 amendments to these provisions, which made the victim fine surcharge mandatory. The general practice in provincial court was for a judge to exempt a person, often on a judge's own initiative, sentencing without a formal application, after the individual was given an opportunity to speak to their financial circumstances. Removing the words in this provision, an offender establishes to the satisfaction of the court that, and also on application of the offender, would restore judges' discretion to make these exemptions as needed, while retaining the presumption that a surcharge will be imposed. A revision such as this one would ensure that the hardship exemption is accessible to people who need it the most. These are people living in poverty, they are generally unrepresented by counsel, and they are often convicted of relatively minor offenses. For example, shoplifting groceries, breach of conditions, and failure to appear, all of which are very common criminal charges in the Downtown Eastside. In addition, we urge the committee to consider how this bill might be expanded to waive the existing surcharges that have been imposed on people who cannot pay them. These are people who have already asked for extensions of time to pay, as this is the only relief currently granted under the existing legislation. We propose that this legislation be amended so that these surcharges are struck from the records of people living in poverty who cannot pay them without seriously compromising their well-being, their safety, and their survival. Thank you for the opportunity to speak to the committee today. We welcome your questions.
Thank you so much. On va passer ça maintenant à...
So our proposed changes to section 737, subsection 5, are simply to remove the language that right now says an offender establishes to the satisfaction of the court that, and then the words on application of the offender. And what we see that as doing is restoring the previous discretion that judges had in practice, and this is what they did in practice in provincial court, which was to speak with an offender at the conclusion of sentencing about the victim surcharge, give the offender an opportunity to speak to their financial circumstances, because we know that for many of these individuals, particularly the clients that Pivot serves, they typically are unrepresented, and they may not even have access to duty counsel. And because the victim surcharge occurs at the very end of sentencing, in practical terms, it's very difficult for these individuals to make a formal application to the court and then to satisfy the burden of establishing to the satisfaction of the court that undue hardship exists.
So the effect of adding the effect of adding that those changes would be to essentially codify the discretion that a judge would have in each and every case. That's the goal.
That's correct.
Yeah. Thank you.
While retaining the presumption that the surcharge will be ordered unless a judge exercises that discretion and the person before them provides some indication that undue hardship exists.
And you take no issue with that presumption? You're okay with that?
Yes. Okay. Pivot absolutely supports the importance of victim services and the importance of funding those services properly. Many of the people that Pivot serves are not just people who find themselves before the court as defendants, but some of them have also themselves been victims of crime. And so this is an important presumption that exists in the code, and we have no objection to the existence of the surcharge itself.
Ms. Shane, you were going to add something?
Certainly. You had raised a question about the practice in BC that is commonplace around sentencing an offender to a day in jail in default payment. And in our submissions as interveners, we actually appended a list of over 100 cases in BC in which a sentencing judge ordered for a surcharge to be payable forthwith, and then in default of payment, ordered that person to be sentenced to a day in jail. And I do want to be very clear that in raising this issue, I'm not in any way attempting to vilify BC judges. Quite the opposite. We are acknowledging that this legislation as it stands puts BC judges in an untenable position where they are faced with a defendant who they know cannot pay, and there are no other reasonable or proportionate means by which to sentence that person. And so it really is, we called it in our factum, an act of mercy rather than malice.
However, if you put a person who's a drug, I mean, I respect that you're saying that, and I understand the motivation, but if you're a drug user and you are in jail for a day, that could itself be very, very difficult for a person. But your point is the judge has no discretion at present, so that's the best you can do, and the BC judges have showed mercy. That will, of course, change with the amendments if they go through in Bill C-75.
Absolutely, and it's in recognition of all of those harms that I outlined in terms of balancing the different possibilities that, unfortunately, is in some ways the least of all evils.